Hello and welcome everyone to another live stream. My name is Andrew Krause and I co-founded InventRight with Stephen Key over 20 years ago and been coaching and mentoring inventors ever since. We're going to do a whole hour of Q&A, so start typing in your questions into the chat and I'll answer them. I see we have 2 people already typed in. Usually by this point, we just got started, but we'll have like 5 or 6 already. So if you want to get one of your questions answered, please type it in now. Don't delay. Oh, very funny, Dana. Dana works for us, and she wrote disclaimer because I always joke that I forget to say the disclaimer until like halfway in. Actually, I was gonna do it on time this time, Dana. But thank you for the reminder. So the disclaimer is anything I share with you on this stream should not be considered legal advice. Please consult your attorney for legal advice. We're just giving general business advice and you're technically not our student because you're not a student of ours, but you're a fan. So just take whatever I say with a grain of salt. But I'm always right. Right, Dana? Right? Yeah, of course. So start typing your questions into the chat. I like to say this at the top for those of you that are going to watch the replay on this. And I'll keep it really brief. Let's try to keep it as short as possible. What licensing is. So what we coach and mentor our students to do is not to start a business and sell the product themselves, but to license. So when you're licensing, it's their money, it's their workforce, and it's their existing distribution. You don't need to raise money, you don't need to hire employees, and you don't need to try to convince retailers to sell to you when you're a company that they've never dealt with before and only has one product, because the company you license to might have 20, 50, 100, thousands of products, okay? So you get everything in one place. And with the InventRight approach, you don't need to mortgage your house and home because you're not spending 10 grand on a patent, 5 grand on a prototype. You're spending 75 bucks on a provisional, maybe a few bucks on a virtual prototype. Doesn't mean that we don't have students that have already filed a patent or have a fancy prototype. We have plenty of students that do, but it means that you don't have to do those things. And most of the time you shouldn't do those things. But you guys can ask me questions on that if you have any questions on that. So let's just jump in here. And everybody can hear me okay? Just type yes, just to make sure. It's always good to make sure. As soon as I see one person says yes, then I'll keep going. There we go. Okay. I don't see anybody saying yes yet, but oh, there we go. Thank you. We got a yes, sir, from Steve Smith. Bunch of yeses. Okay, we're good. Okay, so first one's a handle. You guys also feel free to type in your first name at the beginning of your question, so that I can read off your real first name or a nice first name rather than these silly handles. But I kind of have fun with the handles. So this one's from Recessive Genius. Hi, Andrew. I've been trying to get the question answered for weeks. If I happen to come up with an amazing name for an idea, is there any point of trademarking it if I intend on licensing it? Yeah, I've addressed that many times in these Q&As, but I don't blame you guys if you haven't watched every single minute of all the Q&As I've done. It's usually not worth it. So, and again, what I'm sharing is not legal advice. So consult your trademark attorney. Of course, they're going to want you to file a trademark, but what's the practicality of it? Quite often, they're not going to want to name it what you want to name it. They might sometimes. So what all our students do is what's called a common law trademark. You come up with a name for the product, you throw it on your marketing materials. And the common law trademark is the little TM. So you put a little TM with a circle around it. And the registered trademark is the R with the circle around it. So a common law trademark just means you're putting people on notice that you intend on filing a trademark. You may have not. So for instance, we've been around 21 years at InventRight here. And so we went 18 years, maybe 17 and a half, without filing a trademark. Because we use the product in commerce, because we've been coaching and mentoring inventors in over 65 countries and every state in the United States, if anybody was doing invention coaching and they tried to use the name InventRight, we would toast them. They would, all we'd have to show is all our marketing history that we had been using this trademark in the marketplace called InventRight. And if they were in if they were in a completely different space, it might not be applicable. But in InventRight, you could make an argument. Then we're like, oh no, we use it in commerce, so you don't have to file a trademark in order to get protection from a trademark. So we could have never filed a registered trademark, but after 17 and a half years, we're like, oh, what the hell? Has anybody ever tried to knock off our name? No. If anybody ever did, we would just be able to kick their butt, because trademarks are pretty easy to debate. It's just like, okay, they're in this category and they have this name. That's going to create confusion in the mind of the consumer. Okay, so that's if you're selling the product, but you guys are trying to license. You haven't sold anything. You haven't put it out there in commerce. So does it offer as much protection to you? No, not really. It doesn't offer as much, but it's fine. I've never had a single one of our students that I'm aware of get their idea stolen or taken by a company they had presented to. So if they presented to a company and then one of these companies said, no, screw you, I'm going to take it, or they just said, no, we're not interested, and later they issued it. I've never seen that happen to one of our students. And the reason why that is our students are very professional. Conducting yourselves professionally, for that 3 or 4% of companies that might want to mess with you, they don't want to knock you off. So that's what I'm saying with regards to you sending your ideas into companies. And that applies to trademarks as too. If you got a great name for your product, it's just so unlikely that a company's going to like knock that name off. So what our students do, it doesn't cost them a dime. They put the little TM with the circle around it next to the product name, and 9 times out of 10, they're not going to name it what you want to name it. So they're going to want to name it something else. But if they're interested, you're kind of putting them on notice. Look, this mark means something to me, and I came up with it. And so you can license that. We've had students license that as part of the package, and then you could register and pay for the trademark. But to spend that kind of money, not even knowing if they're going to be interested in, it kind of shows a little bit of naivete on your part too, to think that this big company's going to want to name it what you want to name it. Also, it's kind of like, oh, it's my baby, you have to name it. And if they get an inkling that, you want to make it pink and they want to make it purple and you're going to argue about it, or they want to name it something else and they believe they don't like your name and you're going to fight over that, that's a great way to kill a licensing deal. We don't let our students do that. And our students are level-headed. They don't want to do that. But I've talked to other inventors that do stupid stuff like that. And that is stupid. So the long and short of it, recessive genius, it's funny calling people by their screen name, is I would do a common law trademark. To spend the money on a trademark every time you come up with an idea, trademarking the name, people are way too obsessed with protection. And they screw themselves that way, because you start to spend all this money, and what if you come up with another idea, and your bankroll to bankroll each project is getting bigger and bigger, and it's an unnecessary cost. So if they really like it, then I would register it. Now, could that be a little risky? Could something happen there? Because you're not actually using it in commerce, but yeah, it could. Is it worth the savings? In this case, I would say it is. But again, consult your attorney. I'm not your legal advisor, okay? And of course, the trademark attorneys, oh, yes, you must file the trademark. Of course you're going to say that. So what's the point? Inspirational intelligent athlete is the handle, and they said, thanks, Andrew, you're welcome. I'll call you IIA, I guess. That doesn't make any sense. Diane says, when searching for a company name online, what I'm gonna, when you guys write, if you guys could just write it, like proofread it before you write it, because what I like to do is not reinterpret, but just read what you wrote. I'm going to read what you wrote. When searching for a company name online, what cause a regular MA to know that's not a company name, but a product name? I don't know what a regular MA is. When searching for a company name online, what cause a regular MA to know that's not a company name, but a product name? I don't know what you're talking about, Diane. Can you retype it for me and put it down at the bottom? I appreciate it. I'd be happy to answer it, but I don't know what that means. Sometimes quite often I'll like, I don't know, but I think they mean this. And I think I'm guessing right most of the time. On that one, I'm just not sure. But clarify and I'll answer it. Let's see. Diane Wilson just wrote man. Okay. I don't know what man means. Can you retype the whole question exactly? Oh, okay. When searching for a company name online, what cause a regular company man to know that it's not a company name? But I still don't know what you're talking about. All right. We'll just retype the whole thing and think it through there, and I'll answer it. Ariella, Ariella, yeah. Hello, Andrew. Looking forward to joining the InventRight team family. That's great, Ariella. If you haven't already talked to one of our advisors, just go to InventRight, click on Contact Us, and book an appointment on there. Talk to Sylvia or Dana. They're super friendly, and they'll talk to you. It's never going to be a hardcore sales pitch or anything like that. We don't have used car salespeople working for us. You could even be like, I'm not ready yet, but I might be in a couple of months. I just want to investigate, see what's involved. So go ahead and book with us, and that goes for everybody else too. Steve Smith, how do you categorize your tax ID from your LLC? Leasing, question mark. That's the only part I'm stumped on for tax purposes. I'm not a tax advisor, Steve. So how do you categorize your tax ID for your LLC? That's not really an InventRight thing. You'll be able to find that online very, very easy. So I'm not really completely sure. You say you want to associate your tax ID for an LLC. You can file and you can register with the IRS and get a tax ID and then identify that with an LLC, I believe. I mean, I have an LLC, but I'm not doing the bookkeeping and stuff, so I forget. That should be an easy one for you to find. It's not a licensing question, so I'm sorry I don't have more for you there because I don't want to act like I totally know when I don't remember. I did know at one point, but I'm not doing our bookkeeping and our taxes. So, although we are an LLC. Um, do, do, do. Hello, Andrew, and other non-wacky inventors. That was from Deep Thinker. Yeah, that's great. I mean, yeah, there are Deep Thinker. There are a few whacked out inventors that's making the rest of us look bad. But I say you guys already passed that test. At least most of you probably. Just the fact that you're sitting here listening to me talk about the more boring and mundane but completely necessary aspects to license and sell your ideas, probably you're not completely wacky. The wacky ones will probably get bored after 15 minutes and think they can make $1 million overnight with no effort, and they'll go off and probably get scammed by some invention promotion company or something that caters to their delusions or whatever. But the perception that most inventors are wacky, I think, is incorrect. But there is a percentage out there that are, and they make us all look bad. And if some companies get enough of those guys or gals, they'll stop receiving ideas. But I really don't think it's too bad. What I like about our show is that it filters out the crazies because they hear us, they hear myself, they hear Steven, they hear us talking about the things you need to do. And it doesn't sound like get rich quick overnight. And they hear us talking about the work you have to do. So they don't typically call us and say, I'm interested in coaching. We get a few of them, but not many. So that's when I get somebody that's really off, I'm like, watch our show for a bit and they'll help them get their head on straight a little bit. So, if somebody's really green and clueless, I think that's fine. But there's a difference between that and being wacky. And they are out there. Um, let's see. CEOD. Hi. Oh, hi. Hey, Andrew. Derek here. Do you or will you have an affiliate program? No, we will never have an affiliate program. I'll tell you why. I'll be starting a blog soon and want to send any inventors who follow me to use InventRight on their journey to licensing. We toyed around with it, I don't know, 15 years ago. We don't want people misrepresenting us. We don't want people making claims about us because they're an affiliate or something like that. We have people sending folks to us all the time. Derek, if you get your blog up and you've been up there for a while, you can give me a call and talk. But also, I would send them to our show first because, like I just said, it's a great filter to see if people are serious. So you can send them to our show. But we don't do an affiliate program because we want to control the quality and what's being said. And when you have these affiliates, they're saying all sorts of stuff they shouldn't be saying, making claims they shouldn't be making about the get rich quick program or whatever crap they're selling. So that's the reason why we don't do affiliate programs. And you're just getting up with your blog. But, I tend to not really work with people that just literally got it up because a lot of folks, not saying you, a like they never get it up, or it just disappears like a month or two, or they don't really, their heart's not really in it. But after you've been up for, let's say, 4 or 5 months or so, reach out to me and we can talk. But and in the meantime, hopefully maybe you just send some folks our way. But we're really control freaks about being really honest and transparent with people, and the whole affiliate thing is just, I'm not big on it. Um, okay, Fetters 4. I remember Fetters 4. When making your product, can you ask the company for parts from another manufacturer? Well, I mean, first of all, if those parts aren't proprietary, another manufacturer or another brand might have some certain parts that this company can use in their product. But they may be generic parts. That company may be buying things off the shelf, or the company you license to may just make that part themselves. So, without getting into the details, Fetters for, but one company isn't going to buy a part from another competitor. That's not going to happen. But sometimes people go, "Oh no, if I got Velcro," and I'm doing my dumb voice because this is kind of dumb to think this, but it's okay. People are new, and they're like, "Oh, do I need Velcro's permission to use Velcro?" I'm like, "No. First of all, there's a generic version of Velcro which is called hook and loop fastener, so you don't need to team up with Velcro to put Velcro on your product. Any manufacturer can buy Velcro or hook and loop fastener and put it on their product. So um, I don't know if that would be applicable to you, Fetters for, but um, it might be. So that's some food for thought there. Okay. So take a look at that. But without knowing what your product is, I can't say yay or nay for certain. Um, but in the end, you're just trying to intrigue them with the benefit of your product. Um, Ariella, do you help your mentees with partnering in different categories such as manufacturing, application, and use? Oh, patenting, sorry. Do you help your mentees with patenting in different categories such as manufacturing, application, and use? So, yes, we have a solution that comes with our coaching program called Smart AP, and it guides the inventor to file the provisional patent application. We're not your legal advisor, so we can't tell you specifically what should be in it, but the software that our a patent attorney we teamed up with will guide you through that part. But a big part of what you're doing when you're filing a provisional is thinking about the variations, workarounds, and improvements. You can brainstorm that with your coach. So that's 80% of filing a good provisional. So, um, addressing in the provisional patent, it working in different categories or different versions of it. Yeah, you can brainstorm with your coach. Our coaches are licensing experts. They're not engineering experts, but they could guide you. And most of this stuff doesn't require engineering. It's just kind of obvious, but some of it does. They could guide you and they go, well, I will go here to find that answer or there to find that answer. So yes, we would guide you in brainstorming the variations, workarounds, improvements that you can include in your provisional. Definitely. And we have two versions of doing that. We can refer you to a patent attorney that will file it for you, the provisional, or we can do the DIY version, which is what the vast majority of our students do. There's no need to pay a patent attorney to do a provisional patent application. We can do it yourself. And for those of you that are new, if you ever looked at a patent, you're like, what the heck is that? It's like some sort of foreign language. But a provisional can be written in common English. When you write a provisional, it's not going to look like, nor does it need to look like, a regular patent when you do a patent search. So I always like to say that because people are like, I couldn't write a patent. I'm like, yeah, you can. I have students that don't have a GED that can have had wrote a provisional patent. I've never had a student in all this time we've been doing this that couldn't write their own provisional. And when we've we went back, it wasn't that long ago, actually. It was about 10 months ago. We got permission from some of our students to share their PPA with this attorney we know. And we said, hey, what do you think? What do you think with regards to the quality level that our students were filing their provisionals at? And he's like, whoa, this is like way better than I normally see. Like when I file patents for inventors and they send me their provisional, it's just like, oh my God, it's a mess. But this is great. And we were actually asking him because some of our students want attorney to review their provisional, and I always tell them it's not necessary. But some of them like, no, no, this is a really big project, it's really important. So we wanted to ask if he was cool with it, and he decided said he would do it for like really cheap because he's like, these are really good. Your students do a great job. So hopefully those are encouraging things to say. Um, El Elenardo. In one simple idea, it seems Stephen's approach was to have one simple idea succeed by moving quickly and pitching hundreds of simple ideas. Not really. Thoughts on approaching licensing with only one or a few great ideas. Okay. Yeah. No. So um, the point that Stephen and myself make in one simple idea is that because I don't know if you guys know this, but one simple idea is based on Stephen and myself doing InventRight for a really long time before we did that book. So there are techniques that Stephen and I have come up with over time. And I don't know if you guys know this, but I was the first InventRight coach ever. And I trained our first coaches, and then I was in charge of all the coaches. Now we have a head coach, Terry, that's in charge of all the coaches. So it was techniques that we developed together and then we put into one simple idea. So one of the main approaches in there is, in the end, not necessarily the beginning, but in the end, licensing is a numbers game. You want to work on more than one product, and you don't want 2 or 3 companies for each project. You want maybe 20 or 30. Okay. Some ideas you might only have 8 or 12 companies. If you had a project that was only had literally 2 companies, I wouldn't bother working on it. Now, the thing is, a lot of inventors think they only have 2 companies. I look at the project and I'm like, no, you have like 30 here. You're not thinking about this right. So if you're like, oh no, these are the two, it's because you don't know how to make your list of companies. So yes, it's a numbers game. That's the point we were trying to make in one simple idea. Now, I tell people when they sign up for a coaching program, I don't care if you have any other ideas now, but don't sign up if you never want to work on another idea in your life, because that's just, you're not going to get as much out of the program. So we do 2 things when we coach people is, one, we make sure you do and say everything right with your projects, and then our negotiation coach helps you if any interest you get. So to know that we got your back and you're going to do and say everything right, and you won't feel comfortable on the back end like you're a pro, but companies will perceive you that way because your coach is going to micromanage you in a very positive way, and you're going to check everything with them first before you do it, and you're going to be looking really good to companies. So yes, the goal is to license products, but the other goal is for you to experience a project or two during the 6-month mentoring process where you say, okay guys, I get it, I don't need you anymore, because you got that real life experience. What we found is people don't learn licensing from books and videos. They think they know it, but you don't know anything in life, most things in life, until you do it. I mean, like if you want to be a professional basketball player, you're going to watch videos of people playing basketball or even training videos or read books about it. You got to get out there and freaking play. And it's the same thing with licensing. And so this thought that I just don't understand why people don't think they need training in that area. It blows my mind. Steven in particular, he says it all the time. He's like, why do all these people think they're just going to make it up? Like if you want to be a plumber, if you want to be a doctor, if you want to be a nurse, or if you want to be an administrative assistant, you need training. You don't just jump in and do it. And for some reason, inventors think they can just jump in and do it when they don't know what they're doing. And that's the reason why most inventors fail, because they're doing a ton of stuff wrong. If you just do usually one thing wrong, it'll mess you up. Like if you're not studying the marketplace right, or if your marketing presentation is not good, your list of companies isn't right or extensive enough, or you're not reaching out right, or you're not talking to them right. If you're not doing these things right, so the only way you get that experience is to do it. We can never cover all that in a video. So I just want people to get that experience with a project or two. You shouldn't come out of the gate working on 5 projects. We actually don't let our students do that. We encourage them to work on multiple, but we go, let's get the initial calls in and LinkedIn messages in for number 1 before you start working on number 2. But in the long run, you're going to have more success if you eventually work on 2 or 3 at a time. And you have to gauge that. But I got plenty of people who are perfectly happy working on 1 at a time. Like they got this, 60-hour a week job, and they're just very busy. And it gives them hope because it's something fun, and not everybody works a job they like. And so they're like, this is something, I have hope because of this. It's just the same old drudgery, you know? So there's nothing wrong with working on 1 at a time. But in the long run, if you're really wanting to have success, you should work on more than one. So what I tell new potential students, as long as you have the desire to come with more, you don't have to have a single other idea right now, because that's easy to invent. I can give you the basics of how to invent. Let's talk about that. Most inventors don't do this, and if you guys want to up your game and be better inventors, you're going to do this. And so, what you want to do is study a kind of a broader category. I'll kind of give you the short version. I don't want to go too long on this, but and I always use this example. It's don't work on a barbecue spatula. I just use this example. So let's say you spend 30-40 minutes studying all the barbecue accessories. Okay, let's say you like barbecue. You like doing it on the weekend, fun memories of it with doing it with your family or friends or football games or whatever. And you're going to get onto Google Images and you're going to type in barbecue accessories and you're just going to start looking through all these pictures. And then you're going to like kick back after a little bit and you're going to, and let's say in this particular instance, you're like, everybody's got a barbecue spatula. I think I'm going to go into a deep dive into a micro category. That was more of a broad category. You can't become an expert in barbecue accessories in 4 hours. It's too many, too much. Now, you could become an absolute expert at all the barbecue spatulas in 4 hours, without a doubt. And you could do it like it's 2 hours here, another hour, whatever. You could do it 4 hours at a time, what have you. It's kind of fun. And you don't have anxiety about what you're going to find because you don't have an invention. What happens is, it's kind of stuffy in here. Let me open up these windows. Hold on a second. All right, sorry about that, guys. So it was just getting too hot. I was going to start sweating here or something. So you could become an expert in all the barbecue spatulas in about 4 hours. But when people come up with an idea, and then they got to study the marketplace, most of the time they do a pretty piss poor job of it because they don't want to find it. And I can't tell you how many inventors I talk to, not our students after they sign up, but where they tell me what it is. And I've been doing this for 21 years, longer. And I'm like, oh, okay. And I get it really quick, where they could have been saying the same ramble and other people are like, huh, what are you talking about? And I do a search and I'm like, what about this? And they're like, where do you find that? What did you type in? I'm like, geez, like you didn't do your search, man. And they kind of didn't do it because they didn't want to find it. But guess what? Marketing managers, or they know what's in the category. They're an expert in that category. So let's say it's a barbecue spatula. They know the other barbecue spatulas. You can't be like this horse with blinders on where you're just looking forward, because they will know and you'll just waste a ton of time on a patent, a prototype, a sell sheet, reaching out to 30 companies just for a bunch of them to go, well, this is already done, right? So people have anxiety. So if you come up with an idea, which is most of you come up with an idea and then study the marketplace, that's fine, but do a thorough job. But see, what's refreshing about this approach, you studied a broad category, barbecue accessories. Now you narrowed it down, barbecue spatulas. Like, I can handle this. Okay, now I'm going to do barbecue spatulas. And you look at all the images on Google Images and you type in different keywords and you're looking for the benefits, you're looking for how they're marketing it, you're looking for the price points, you're looking for different features and stuff like that. You're like, oh, there's like 5 over here that do this, and there's those ones that do that, and then there's this combo tool that does this. And you have no anxiety because you don't have an invention, right? And then you invent. Now you're an expert in the micro category. This is the way, this is really the only way, if you want to save time, that every inventor should invent, but almost no inventor is inventing this way. This is the way you guys should invent. So, Leonardo, if you are like, I got this one idea, but I don't know if I have more ideas, play around with that a little bit and it will come to you. Now, if you spend 4 hours solid, or let's say 3 hours solid, or 2, your brain might be fried. And so don't feel like you have to invent during that process. It's kind of like a little better that you don't. Maybe you write a thought down because you want to kind of really get an idea of the space first and then invent. So once you understand that space, now you bookmarked all that stuff. You get fancy, you put in Evernote, or you just bookmark in your browser, whatever the heck you want to do. But you got to bookmark those images and those pages where you found those products. And then maybe you're taking a shower, maybe you're driving down the street, and it'll just come to you. Or maybe you sit back, probably do this, sit back at your computer, look at all that stuff again, and it will come to you. If you came up with one idea and you do this, guaranteed, guaranteed, you will come up with more. Doesn't mean it'll happen every time. Maybe do this barbecue spatulas, and then time goes by and you come back and look at them again. It's just nothing's popping. And it might pop a year from now or 5 months from now. And then, or it might come to you right away. But then you're like, okay, no problem. That didn't work. I'm going to study another category. But this is fun. And you don't have the anxiety about finding something that's similar to yours. Um, so if you just have one idea, and as long as you're confident with that process, and any of you can do this, you don't have to have more ideas. Get started with that one idea. Start trying to license it, whether we're helping you or doing it on your own, and get that experience. And then you can come up with more ideas. Don't second guess yourself. Any of you guys can come up with more ideas if, here's the caveat, if you have the desire. If you tell me, when I sometimes, very rarely, I have people like, this idea, oh, this is a big idea, and I'm like, great, yeah, that's pretty cool. And they're like, I'm like, great, we're going to teach the process. No, 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 I want you to do this for me. I'm like, well, that's not what we do. We're going to guide you to do it. And he's like, well, I'm not an inventor. I never want to do this again. I hear this not very often, but occasionally. You know what I would tell that person? I'd say, don't sign up, because you're going to take all that experience we give you and you're never going to use it again, ever. But that's not most inventors. Most inventors, I talk to some, they got hundreds of ideas, 50, 25. I come up with them all the time. I don't write them down right off the top of my head, but I have other ideas. And all I say is, do you have the desire to come up with more? That is the only litmus test as to whether or not it makes sense to work on licensing your products. So I did a long ramble. Hopefully that was helpful, Leonardo. Let's see. Concrete says, hello, when contacting people and companies on LinkedIn, should we send initial contact message to the contact's email too, as well as a message on LinkedIn? Thanks. Yeah, I think that's perfectly fine. Realize that sometimes when you click on the contact button, contact info button on LinkedIn, they might be using a junk email there, because anybody can see that. They might set it so you can't see it unless you're part of the network. It really depends. But I think that's perfectly fine. Both just asking for permission to send and not sending anything ever unsolicited. That's just a big no-no. Let's see. What was it? Diane had a question. Diane, you didn't type your question in again. Oh, here we go. Okay. Hi, Andrew. When looking up a company's online to pitch your sell sheet, how will I know I'm looking at the company's name and not a product name? When looking up a company online, I don't know what that means. I'm looking at the company name and not the product name. Okay, so well, obviously you have a product. So let's say you're doing door stops, okay, and you find a company that's selling door stops at Walmart, okay, and the product has a name, that doorstop has a name, and preferably on the online version, on Walmart.com or wherever you're seeing it, or at the store, it'll say the name of the manufacturer. Now, won't always say that. If you're at the store, you can turn over the package and this is manufactured by so and so, right? Now, sometimes this is a nice little tip. It's a detailed tip, but if you find a website, a retailing website where you find a product, you're like, oh, that company, I think that'd be a good match for my product. You can take the name of the product and Google the name of that product. And if like Walmart.com isn't showing the name of the manufacturer, and sometimes you can zoom in on the box and you can go, oh, I can read it there. There's the name of the company. Just instead, if you get the name of the product, just paste it into Google and see other sites where that same product is showing up, and maybe they'll list the name of the manufacturer, or they got a different picture where you can zoom in and see the name of the product on the back of the package. So hopefully that was helpful, Diane. Thank you for retyping your question. Appreciate that. Jeff said, speaking of great names for products, is it a good idea to give the product a name on the sell sheet, or is it the description sufficient automatic bottle opener or bottle popper extreme. It really depends. I like descriptive names. So descriptive names kind of tell you what it is. I think that's more important because a marketing manager is going to look at your sell sheet. You have 6 to 10 seconds. That's it, guys. They're not sitting over there mulling over it. They're not going to go to your website. They're gonna not going to like try to figure it out. If they don't get it in 6 to 10 seconds, you're toast, and they'll go, "I'm not interested." Okay, so descriptive names can be very nice. I think when you get too fancy with the name and it's like two steps down the path, like you understand the product and now the name makes sense, don't do those. If it's a fanciful name, but it's also descriptive, like your example here, instead of automatic bottle opener, you put bottle popper extreme. Okay, so bottle popper is kind of saying, if you have the right picture, saying it's a bottle opener too, maybe extreme. So I like descriptive names, and it might be less sexy, but like I said, they're going to rename it something else 9 out of 10 times. So that's not important. What's more important than a good name is that they get what the product is. So sometimes people have been thinking about it so long, you're so familiar with your product, but they're only giving it 6 to 10 seconds. If you get too fancy with it, you're just confusing them. If it's descriptive, you see the description, you see the benefit statement, you see the picture, boom, they get it. But if it's really fanciful name, so you could have a fancy name, but if the rest of it, oh, boom, I get it. Okay. But so I'm not really big on getting too fancy with the names because most people do a pretty bad job of that. And but it really depends. It really depends. That's one of the things, you have a coach that would be guiding you on all that if you're a student of ours, and they'd help you. When you do something like sell sheets, like our coaches do over and over and over again all day long, every week, and you're helping students, that creative process is very natural for them. So they're your like marketing wizard. And you start to get a feel for it, you get better at it. But the kind of being a good marketer is something that takes a little bit of practice. um, and I don't find most inventors are good marketers naturally. Few are. Some are okay. Okay is not good enough. You need to understand it in 6 to 10 seconds. So it's a skill that you guys all need to hone. Just like any skill, the more you do it, the better you get at it. So yeah, I'm saying that most inventors, their marketing's not good, but when people leave us, they get good at it. A few of them still struggle with it and still need help. But the more you do it, just like anything, the better you get at it. So this is Frank. Can I use brands, trademarks, or prior art in my prototype or 3D rendering? So yeah, there's something called fair use. You can go on Wikipedia and you can look it up. It's called fair use, FAIR use. And so when you're using a brand name or a picture of somebody else's product or whatever in a sell sheet or video that you're privately sending a marketing manager at a company, that's called fair use. And you want a disclaimer at the bottom that says all trademarks, logos, and products are for illustrative purposes, and their rights are with their respective owners for illustrative and demonstration purposes only. So you can use brand names and stuff in there if it's applicable. Now what you can't do, and I had this happen. I had a student, and some of you heard this story before, and he was doing something to do with football, and we didn't know he had a website, and we were helping him, and he had a coach, but he called me up in a panic, and he said, the NFL is saying they're going to sue me, and I'm like, why are they going to sue you? He's like, well, I put up a website and I have all the team names up there and an NFL logo. I'm like, whoa, what are you doing, dude? You can't do that. That's their brand. You can't do that. And I gave him advice. I said, look, take it down like a millisecond from now and let them know you did. And they never got back to him and they never sued him. But you can't publicly use other people's brands and products. But if you're privately showing it for illustrative purposes, and you say that at the bottom is for illustrative purposes only, and all brands, trademarks, and products are rights to their respectful owners, and you make that clear, it's called fair use. Now, there's certain, so that is something you can do as long as you're not misleading. You don't want to ever mislead anybody that you own those brands, but you're privately just showing it to one person. You're not messing with their brand. But I'm sure there's a line there that you wouldn't want to cross, but ask if it's really necessary. But yeah, sometimes, you'll cannibalize another product. Maybe you get a Photoshop, something like that. And that's pretty normal. You're just showing what could be done, but you're not going to use that actual picture when you're finalized. You're not going to use those brands or what have you. Um, so that was a great question. Thank you, Frank. That was for Frank. Um, Mariana, are the inventRight licensing steps the same for intangible ideas, like for an original cartoon character or kids book series, and wanting to license it into a show? So we have helped students do things like that, but here's the deal. Let's say it's Ugly Dolls. That's something that's been around forever. So these Ugly Dolls, I don't know if you Google it. I haven't looked at that in like eons. But if the cute character stands up on its own and it's like ugly or edgy or fun or gross or whatever, and people saw it on a T-shirt or they saw the doll or the whatever, and they're like, "Yeah, I buy that," and there's no show and there's no comic book, then go for it, license that. But to tell people they should license your character and the character is not intriguing in and of itself when there is no TV show, that's not going to work, right? Why are they going to license this brand with this backstory? They don't have an opportunity to tell the backstory unless it was just very obvious on the packaging and people just looked at it and said, "Oh, that's fun," or "That's cute," or that's edgy. I like that. I'm going to buy that. Or I want that T-shirt with that funky character on there. But if it's required for the TV show to exist, it's hard to license these products and do essentially brand licensing when you have no TV show. It's kind of putting the cart before the horse, if you will. So now the license, so we can teach you how to license characters. We've had students do it. You can totally do that. Question is, does it stand up on its own without any kid or an adult knowing about a TV show? So that's the big question. Now, licensing to Hollywood or publishing a book is a different kind of licensing. I don't want to deal with it. We've been candidates for, I think at this point, 4 or 5 TV shows. None of them ever worked out. They make these big promises, all this Hollywood bullshit talk. I'm hopefully there's no kids listening, but so be careful because my daughter's 9. She gets all upset when I swear, which I almost never do. Um, but so I'm not. We are not the ones to teach you how to pitch Hollywood. Okay. And so you got to ask yourself, does this stand up on its own? And are you going to be doing character licensing for this before you sold a single book or there's a TV show or something? Now, maybe one could play off the other. Or maybe you do the character licensing and it does stand up on its own. They see it's successful and people love the character and then you do the show. Or maybe you do the show and then you do the character. But it's got to stand up on its own. Okay. Let's see. Okay, this one is from Revaj Hernandez. Andrew, 2 weeks ago, a toy company sent me an NDA. They told me to sign and resend the attachment. I did. Is it a good time to contact them back to check the status, or should I give them more time? Thank you. 2 weeks ago. I would give them a little bit more time. And here's the thing. When inventors don't want to give companies time, you know what the problem is? It's on you because you're not keeping yourself busy with reaching out to more companies. When you only reach out to 1 or 2 or 3 companies, you're sitting around. You can't help but to think about that submission. And then you're going to reach out to them too soon. You're going to bug them, and then you're going to be put in the amateur pile because you're pestering them. So I don't think 2 weeks is long enough. Now, they specifically asked for the NDA. I'd give another week. I think 3 weeks is fine. Maybe 4, but friendly follow-up. And when you follow up, make sure you reply so they can see what you sent. They can see the NDA. They can see the communications. So you're not like, did you get it? Have you looked at it yet? And that's all you say in the email. Like they can see everything. It's all neat and clean right there for them, the whole email chain. Okay. So I would wait another week. I think that's fine. But what you should have really done when you sent it in is said, what's your process? What's the timeline for receiving some sort of comments back? Just ask that initially, and then you wouldn't be asking me. And it's going to vary tremendously with different products. Um, and I'm not saying you're anxious, but reach out to more companies. If you just do it one at a time, then you wait for a response, you're going to shoot your head on yourself sitting around waiting. That's going to take forever. That's not playing the numbers game. So keep reaching out to more companies. You will never be successful reaching out to 2 or 3 companies per invention ever. If not, you're getting really freaking lucky. And that's the reason, one of the reasons why our students are successful, because we force them to create a nice big list of companies, not their favorite 2 or 3 companies that are right in front of their face and were easy to find, or they're just the biggest companies in the world or whatever. That's amateur hour. Don't do that. So, but you're in the game, Ravage. I think I'm saying that right. Because you're reaching out. That's fantastic, man. You're doing great. Deep Thinker, oh, Misha is her name, or his, I'm not sure. I've created a product that could be a great accessory for a Starbucks product. Web indicates they don't accept outside ideas, but having a hard time letting go. Worth looking for a back door. So Starbucks is Starbucks. Most of the time, you wouldn't license Starbucks. So Starbucks is a retailer. They sell coffee. So why would you try to license to Starbucks? License to the manufacturers that sell to Starbucks. So if they're selling a coffee sleeve, if they're selling a plastic cup, if they're selling a glass cup, if they're selling some coffee accessory. So find the manufacturers that sell to Starbucks and license to them, and they will get it into Starbucks, and as well a ton of other places. So that's the limited thinking that I see most inventors have. It's like, well, what about all the other coffee chains? And could this be in stores too? Does it have to be in a coffee shop? Could it be in a big box retailer? Could it be in a drugstore? Without knowing your product, I can't say. But yeah, it's worth, I like your thinking, Misha. It's worth looking for a back door. You're absolutely right. That's not a back door, that's the front door. But you just don't know how to do licensing yet, and you're just getting used to it, which is fine. So you're probably not going to, is there some isolated instance where it might make sense to reach out to Starbucks instead of these other ones? Yeah, but they're really impossible to work with. I've had a lot of people try to reach out to them over the years. It's basically impossible. But you can get, if you license to one of their companies, then they can get it into Starbucks, as well as everywhere else they distribute. Let's see. Steve Smith, thanks, Andrew. When setting up the LLC and tax ID, request what type of business you're in, since you usually mention licensing and leasing, and there is no licensing option through the IRS. It doesn't matter. It doesn't matter what you put whatever. You could put product development. I would put product development, but it doesn't matter. As far as I know, it's not going to affect like the way they tax you or anything like that. So I would put product development. That's what you're doing basically. You just didn't know what word. So there you go. Derek said, I've signed the NDA a company has sent me. How do I get the company to pay for the patent on the product? Well, you're getting ahead of yourself there, Derek. A company signed your NDA. I signed the NDA. The company wanted you to sign theirs. So you signed it. I'm sure you read it to make sure it's okay. You're okay with it. You sent it. And now you're asking how this is just for illustrative purposes because it's just something you type. So I'm not giving you a hard time. But now you're asking about how to get the company to pay for the patent. You're asking the wrong question. It's not the wrong question. It's a good question. But how about how to have a conversation with them and how to move the deal along so you can get to a licensing contract and then be able to discuss about them paying for your patent. But so that's never the first thing you're going to discuss. So I love your question because it's really helpful for a lot of folks. That's not something you're going to be talking about on the first call, even remotely. So you filed a provisional patent, hopefully, and then as you move forward towards licensing deal, you're going to gauge how interested they are in filing a patent. Our students do deals all the time. Companies like, we don't care about patents. Yeah, we'll sign a contract, say we have to pay you for the product. That's shocking to a lot of people. Our students do it all the freaking time. I got a student right now I was just talking to he's in Bali, and he's an American. I didn't ask him he's American, but American accent, and he lives in Bali, like super cheap little beach like resort, and he's licensing because it doesn't matter where you live. He told me I could live on like 50, he lives on like 15K or less a year in Bali, but he's telling me the humidity is just like he's just a little side note, guys. Sorry to ramble, but he said if he doesn't take all his clothes every 2 months and wash them, they get moldy. Isn't that kind of humidity would drive me insane? I live in the desert where I live in Las Vegas, Henderson area, and there's just like no humidity. When I go to LA every once in a while for vacation or San Diego, I'm like, it's so humid here. You can imagine what it is in Bali. But anyway, where was I getting with that? So, uh, why was I talking about that guy? I forget. So how do I get the company to pay for the patent? Oh, yeah. So this guy, the patent ended up being important to him. And so in that case, you can, in lieu of upfront money, you can say, well, when you ask for the upfront money, you say, I'm just asking for this as an advance on royalties. So it will protect you and protect me if they care about a patent. And then I'm going to use that to pay my patent attorney to upgrade the provisional to a full utility. And so basically the basics of that is get them to give you some upfront money. That's enough to pay for the patent. Now, one of the things, this is a detail, guys, but this is a great tip. When some companies are thinking about patents, the figure in their mind is $20,000, when you could probably get one for like 6 or 8 with a competent independent practitioner, not a firm. And so I think it's very important to say you have a very competent independent practitioner, and it can be done for this price, because when you're not thinking the same thing. They're thinking 25K and you're thinking 7. So you need to say 7. I have a very competent independent practitioner that can file this patent and will protect you and protect me. And, I would like to talk about an advance on royalties. So what an advance on royalties is, they're going to give you the money, no money out of your pocket, and you're going to keep that. You're not giving that back. And then you can give that to money to your attorney, and they can file a provisional patent. Now, the first 7,000 in royalties, they're going to keep, because they paid for your patent, which is yours, not theirs. Okay. Companies you don't want companies filing patents for you guys. It's always in your name. And then the contract gives them the rights to manufacture it. So if you have to pull the contract because they're not performing, you don't want to have them reassign it back to you. That's just a mess. You do not want that. We advise our students never to do that. And they haven't run into that problem because of that advice. So it's a discussion you have. There's a lot more to cover there. It's when you get into a negotiation, it's like moving around a bunch of cups, and I got to go, oh, okay, you're there. Okay, this is what I would do. And it's going to be different in every scenario. So, but those are the basics that I think will help you, Derek, and everybody else. And forget about that whole thing right now. Move the deal forward. If you don't know how to do that, call us. We'll help you moving it forward. Now, you just signed the NDA and sent it. They didn't even show interest in it yet. So they didn't even show interest in it yet, because I don't see anything about you saying they showed interest. You just sent the product in, and you're already thinking about how they can pay for the patent, which is a good question. It's not a bad question. You got to think a couple steps ahead and know how to handle that. Otherwise, you're going to feel uncomfortable when the time comes. So this is a perfectly good question. Let's see. Delucy82, should I get the LLC before licensing? Most of our students don't. I always say, when you're in the midst of a licensing deal, our negotiation coach insists that our students file an LLC and do it under the LLC and not their own name. So that's a no-brainer, an absolute must. But if you don't do it until you get to the tail end of a deal, that's perfectly fine. It's never bit one of our students in the butt. I don't see it as being a big issue. Do you need a website? Hell no. And you don't need a website. Don't do a website, please. You put first of all, you shouldn't be putting products up on your website, publicly disclosing products. Don't do that. Now, if you've been selling your product and venturing it, that's fine, but it's completely unnecessary. You're going to email a PDF or an unlisted YouTube video that nobody can see except for people with the link. So you do not need a website by any stretch of the imagination. Complete and utter waste of time. If for some reason you had to, and you want to use your domain name, like bobsmithdesigns.com or something, bob@bobsmithdesigns.com. Have that website very general, like it could be a one-page website. We design and license, we design, develop, and license new products. Have a little one-pager, and then contact information. Um, and you don't need a domain name either. You could use bobsmithdesigns@gmail and you're good to go. A lot of corporate people use Gmail. I'm not promoting Gmail in a lot of ways. Sometimes I'm not a fan of Google and some of the things they do, but um, if you want to use your own domain name like bobsmith.com, and some people do that, but then the website's not there, and that's always a little bit awkward. It's like, well, I don't see anything on the website. Like the email's functional with that domain name, but there's no website. So in that case, just one page splash page, but don't put any products up there ever. It's a waste of time. It's also, you're asking to jump through hoops. If it's right in front of their face in the email, that's what you want. You want them clicking off to your website. You don't want to make public disclosures. So be careful about that. Mama Africa, I just need someone in the USA to partner with. Well, that's what licensing is. So when you're going to license to the manufacturer that sells to the retailer, they're your partner, and they do. It's going to be their money, their workforce, and their distribution. You need to learn how to license, and that's what licensing is. But you need to know the process. You need to be a business person. You can't just have an idea and, I just need somebody to partner with. Yeah, you need to learn how to reach out, and nothing will ever happen if you don't bother to do that. But you're taking the time to listen to me ramble for an hour, so that's your first step. Let's see. Oh, did I skip your question? Let's see, Brian. I don't see your question, Brian. Brian said I skipped his question, but there we go. Okay. Yeah, I do see it there. Sorry, I didn't mean to do that, Brian. If I plan on becoming an inventRight student at any point, do you guys claim a percentage if the product gets the deal? Absolutely freaking not. There's a bunch of reasons for that. First of all, these invention promotion scam companies that take you for 10 or 12 grand, pretend to work on your idea, their sales ploy is they go, we want a piece of your invention. This is great. This is fantastic. And they'll be like, oh, we want 10%, 20%. Quite often it's like 20%, 30%. And it's a ploy to make you believe they care about you and are actually going to work on your product when they really want is the 10 grand or 12 grand they're asking. And so it's a ploy. So that's one reason we don't do it. Another reason we don't do it is I don't want a student that's like at the tail end of a deal and they don't reach out to our negotiation coach, Paul, to help them close it out because they want to secretly try to close the deal on their own. And then it mucks them up because that is difficult to do. To finalize that deal and have that back and forth with the company. So I wouldn't want somebody going, oh, I don't want to pay inventRight their 20%. So I'm going to try to close this on myself on my own. I'll tell Paul that I didn't get interest, or that they fell off or what have you. I never want that. I want people to not even think for a second to ask for our help. I could think of a bunch of other reasons as well. I think the main reason is we're all about empowering you guys. We're about empowering you so you can say, I get it. I don't need you anymore. I can do this the rest of my life. We're here to support people while they're going through the process because people make a lot of false assumptions. And, when we can see an email and we're like, oh, yeah, companies will say that all the time. Here's how to respond to that. And you get another email and the student's like, oh, this is terrible. This is going to happen all the time. And coach is like, I've never seen anybody ask that at all. That's a weird thing to ask. That guy's weird. But okay, here's how we're going to answer it. So you start to put things in perspective and you get that real life experience. It's like you can't learn to play basketball unless you actually play. You can't watch video trainings about basketball and learn basketball. Same freaking thing. It applies to most businesses. But for some reason, people think they can just start blasting things out and they're not successful with that. So, but no, that's the reason why we never ask for a percentage. Not only that, everything's confidential. We sign an NDA. If a coach is like, hey, you can improve this like this or that, which they do sometimes, everything is yours. So it's a very transparent relationship. We've never had a problem in 20, 21 years. I say 2021 because I'm not keeping track. It's like right around there. Um, I'm not sure if we're ripe for drinking age yet here, but so okay, we hit the hour. I did not. Wow, I did not get to everybody's questions. You guys had a lot of great questions. For those of you that I didn't get to your question, next time show up earlier. Type your questions in earlier, and I will be back next Monday. I'm going to ask the favor I always ask. I spent a whole hour completely free answering your guys' questions. Even if I didn't answer your question, I answered a bunch of other people's questions. You benefited from the solution. So click on the subscribe button, click on the reminder button to know when new videos come out, and then just like all our videos if you can. That's the way you could say thank you to me, by getting even more education from us and liking our videos and subscribing. I would love to, 8 months from now, be at 80,000 subscribers. We're at 50 something thousand. That would be huge for us. So please help us out there. And I remind you guys to take care, keep inventing. Again, if you guys are joining late, my name is Andrew Krause. I co-founded InventRight 21 years ago, and we've been doing this ever since. And we have a lot of successful students. So if you want to book with us, go to inventright.com and click on Contact Us, and Dana or Sylvia will talk to you about the program. Even if you're like, I'm not ready to sign up now, I just want to know what it is and figure out if this is right for me. They're very chill. They will not hound you. They'll not hard sell you. They're very friendly. And we're so hands off about promoting what we do in our coaching that we get people all the time, oh, I didn't know you guys coached. I'm like, do you hear us constantly referring to our students? What did you think that was? But I think so. Sometimes I think we don't want to be some schmucks that are just constantly promoting our coaching program and stuff. But at the same time, I don't think we talk about it enough, because so many people are like, oh, I didn't know you guys did that. And so, we don't make money off our YouTube show the way that we pay all our employees and the way we support people. And the reason why we're able to have all these great programs like Bridging the Gap and all these other programs is because we do have to charge to mentor and coach people for literally half a year with a negotiation coach. We do a sell sheet. We do a virtual prototype. We give you software to file a provisional patent. I'm biased because I'm a co-founder, but people tell me all the time it's well worth the money. Look at our testimonial page if you want to find out more. Anyway, I'll let you guys go. Take care. Keep inventing. I'll catch you with you next time. Bye.